request you guide us with your wonderful experiences.
Okay. Should I share my screen first?
Yes, sir, you can share.
Now give me the permission to share my screen. Is it visible?
Yes, Dr. Panda, it is visible.
Okay. Okay. Now, please, Anuradha madam, you just check the slide whether it is changing or not. हो रहा है, change हो रहा है? Put on your, just unmute your mic first.
Yes, it's changing.
Okay.
Yes, sir, it is changing, sir.
Okay. If you face any kind of problem while displaying the presentation, you please convey me. Otherwise,
Sure, sir.
I am changing the slides, but actually, I'm thankful to Kiran ma'am for giving me the opportunity to speak on intellectual property right. And this is one of the hot topic nowadays, and everyone is trying for the intellectual property, and we should go for intellectual property protection, because in ancient time we have not protected some of our basic things, and currently other countries, they are claiming their rights over there, like haldi or neem. So it is better we should protect our intellectual property time to time, and everyone, generally people say, this is a it is creating a havoc, in fact, that everyone cannot file the IPR, but it is not true. Everyone is having the intellectual property and they should protect their property. They doesn't know how to protect it. That is the disadvantage. So I am thankful to M.D.S.D college for taking the initiative for the awareness of intellectual property among the users, among the intellectuals. Now, before starting the IPR issues, I would like to say how we file the IPR, from where we get the input for IPR. So I'll speak in English and Hindi in mix, so that we can make the lecture very interesting, and you can ask the questions if you understand the things well. So,
Sir, we have participants from various parts of the country, so it will be good if it will be bilingual, na?
okay. So, yeah, all are Indians, huh? Not foreigners.
Yes, they all are Indian, sir.
Okay.
So some are from the south, so that's why she must be talking about that.
Okay.
So they may not be very well versant with Hindi. Of course, Hindi is our mother language. Everybody should understand
Everyone
that.
should know Hindi, madam.
Madam should know Hindi.
Everyone should know Hindi. This is the problem.
Yeah.
This is the problem. We are talking in English, and we always ignore Hindi,
Yeah.
because it is a status symbol, in fact.
Yes, sir. Yes, sir. But not. बिल्कुल
It is a
ठीक
status
कहा
symbol.
आपने. Yes, sir. बिल्कुल ठीक कहा. मुझे लगता है कि हिंदी वी शुड, और हिंदी एक ऐसी अपनी मदर टंग है जिसमें हम एक दूसरे से जब बातचीत करते हैं तो एक दूसरे को अच्छे से समझा सकते हैं.
Recently, madam, we got one grant from Erasmus, that is European grant.
अच्छा.
In that grant, we are promoting the English, HINGILSH.
अच्छा.
Hindi version of English.
Okay.
That means if you're talking on a particular topic, if you're using the mother language, your mother tongue, you can convey the things in a better way, and the other part of the counter, they can understand the things in a better way. And
Yes.
in national education policy, they are also giving more stress on the mother tongue.
Yes.
Right? So if you want to understand the things, you have to use the mother tongue, not the foreign language. What I feel. But no, whenever we are giving the examples, we should give the desi examples. हम कहते थे ना, देसी example दो तो समझ आएगा बहुत अच्छी तरह से. ठीक है. So similarly, I am giving some examples, and the entire lecture is filled with a lot of examples, real-time examples, right? So what is the input of IPR? The input of IPR is our innovations. And from where we get the innovation? Innovation is our creativity. Every human being is innovating each and every second. But what we are doing, we are not giving stress on those innovations, and we kill those innovations. Suppose we see a particular problem in a village, and we got an idea to solve that particular problem. Okay, I just seen a problem of vaccination in villages, and I got one idea how I will initiate the vaccination system in villages, how the vaccine will reach to the villages, and how we will spread the awareness. I got an idea. I generate an idea, right? But I have not taken any action on that particular idea. That means I have killed that particular idea. So in every moment, the human beings, they are generating idea, they are generating the innovations by their creativeness, by using their creativity, but they kill their innovations after some time. So here the input of intellectual property is your innovations. Always remember, right? So what the innovation is and how you will protect or how you will finish your innovations. Suppose I got an idea. I'm giving one example. I want to protect, I want to save the life of a person, those who are traveling or those who are under transition in ambulance. Suppose a patient is under transition in ambulance, and I want to give the medical aid. So it is not possible to provide doctors in each and every ambulance, because in India we have around 10,000, one doctor out of 10,000 patients. So it is 1:10,000 ratio. So it is not possible to provide doctors in each and every ambulance. So can we provide any machine which can be connected to the internet, and with the help of smartphone, doctor can give the medical aid to the patient in the ambulance? That is possible. So if I develop a particular device, then I can protect my intellectual property with Government of India, so that no one can copy that particular intellectual property, and no one can steal that particular intellectual property. Otherwise, the people will get the idea from you, and they will develop their own. So the input of intellectual property is always innovations, or your own idea, or your own creations, right? Now, intellectual property refers to the creation of the mind, right? Whenever we are using our mind, we are developing some intellectual things, some intellectual contents, and that is our own content. We can claim it is my own content. Suppose I am writing a poem by using my own creativeness, or creativity, or my own idea, my own thinking, my own way of working. It is my own creation. This is my own property, intellectual property, and I need to protect that particular property from theft or the stealing. Now, the intellectual properties are inventions, the literary artistic works, designs, symbols, names. Those are used in commerce or other sectors. Now, what the significance of intellectual property? First significant is to avoid the duplicate of research. Suppose you have developed something new, something novel, you can protect it, and you can avoid the duplication of research. You can publish the patent. That means whatever idea you have, whatever creativity you have, you can publish it. Transferring invention as a public property. After that, you can transfer the invention to the public property also. And try to understand the difference between the invention and innovations. If I give some examples, suppose microwave. Microwave is an invention. But by using microwave, if a person develop a particular device to cook the food, in such case, it is an innovation. Suppose X-ray. X-ray is an invention. But by using the X-ray, if I see the condition of my bones, that is an invention, healthcare device. By using the X-ray, if I can see the content of a luggage, that is an innovation. So in innovation, we are using the inventions, right? So this is the difference between the invention and innovations. Then by using the IPR, you will get the profits and royalty. You can claim your own work and you can transfer the work to some company, or you will get the royalty, you will get the profit, or you can sell that particular technology, you can transfer that particular technology. So these are the indicators of significant of IPR. You will find more significant like commercial scale or commercially exploited, negotiating the licensing, franchisee you can give the legal proceedings, preventing the competitors, you can expanding the market share. Lot of significance are there, tax savings are there, market value, valuation of company. So many things are there as a significant of IPR. Now, try to understand the IPR in a very, very simple way. You have to know about these 5-6 points. These are the tools of the IPR. Number 1 is copyright. Number 2 is patent. Number 3, trademark. Then industrial designs. Then geographical indications and trade secret. If you understand these 6 points, you can understand each and everything in IPR. You will not find nothing more than these things, these tools, right? So first of all, we go through the copyright. So which things we can do the copyright? Suppose I am developing a machine. I cannot copyright the machine, right? I cannot file the copyright of a machine, right? Suppose I am writing a poem. Suppose I am writing a story. Suppose I am developing a movie. Suppose I am developing a music. Suppose I am doing a paintings. Suppose I am developing some softwares. Such kind of things we can perform the copyright protection. I think you might have understood where we can implement the copyright. Copyright cannot be implemented on the machines. Suppose I am developing a machine, right? And I cannot file the copyright. Yes, suppose I am writing a manual to operate that particular machine, or I am developing some SOP to operate that particular machine, that may be considered as a copyright, right? So any literary work. So why you do the copyright? Because unauthorized copying and reproduction of the original expression. And the term of the copyright is life of the author plus 60 years. That means that is the life of the author plus 60 years. This is the survival of copyright. I think you might have understood about the copyright. If you have any kind of doubt, you can unmute and ask the questions. Okay.
Yes, sir.
Otherwise, at the end, we will give the opportunity to ask the questions. Even after the lecture, I will give my mail address and phone number. You can ask me whenever you feel any problem while filing the patents or copyrights or any intellectual property protections, you can ask. So these are the things which are covered under copyright, like literary work, any literary work or films or dramatic, where your creativity works, your original work is there, you are not copying the work from somewhere else. So those things you can file the copyright, like musics, the artistic works or the sound recordings. Such kind of things are considered as a copyright protection. Another one is the patent. This is the exclusive privilege, right? Exclusive right granted by the government to the patentee. And the duration of the patent filing is, if you're filing the patent, it is 20 years valid from the filing, date of filing. And we can use it for the commercial gain. Okay. Next, we have to give the disclosures, entire disclosure of that particular machine or that particular process. Then only you will be able to file the patent. Like visual symbols, which may be word, so I can give the example of patents. Later on, I will give the examples. I have just explained the brief terms, right? Then we go through the examples. I think you might have understood about the patent. Next is the trademark. Trademark or the brand name. You might have seen the trademark of many companies, like even I can say in shoes, you will find the trademark of M.D.S.D, or you will find the trademark of McDonald's, you will find the trademark of KFC, right? Just some symbols. You can see Intel, like Sony, Microsoft. You just see which font they have used and what kind of design they have made. You will find the trademark of Mercedes, Maruti, Toyota, right? So these are the symbols generally used by the company. Whenever the company will design a particular symbol, they will register it under IPR with the government of India as a trademark registration. And once they will register that particular trademark, no one can copy that trademark in their products. And you will see a lot of trademarks every day. Another one is design. Design means only the feature of the shape, configurations, patterns, compositions of lines, colors, and you will find lot of commodities nowadays with lot of designs. If you go to market and if you want to purchase a particular shoe, you will find lot of designs. Similarly, if you are going to purchase some mobile phone or some water bottles or any item, any commodity you are going to purchase, you will find lot of designs. So company will protect their designs with the IPR, with Government of India, by giving the detail of the design, the size of the design, and the concept of the design. Right. Similarly, people are filing the design of different pen, different kind of pen. One pen can use to clean the mobile phone. By using that particular pen, you can operate the mobile phone. By using that particular pen, you can just hold the mobile phone. So a lot of things are there, and lot of designs you will find in market, and we need to protect our design so that no one can copy that particular design. Now you can see the example of designs. These designs are developed by our own center of excellence. There is a design to sanitize our hand automatically. That is a watch-like of thing is there where we can fill the sanitizer and put the alarm, and time to time it will automatically sanitize our hand. So it is very useful for the doctors, those who are working in COVID ward. Time to time, automatically it will sanitize their hand so that they can avoid the infections. Similarly, these are the different design of toilets, smart toilet systems, which can be used at home or in hospitals for elderly persons or for the disabled person or for the patients. Similarly, we have designed one smart and portable intensive care unit, which can be kept in a ambulance and which can provide the immediate medical facility or emergency injections to the patient by the doctor from the smartphone. So these are our own design patents, what I am saying. So design must be appealable to the eye. Design is a beautifying and industrial product to attract the customers, right? More functional or technical features we can give in design. Now, mere functional or technical features of the articles are not considered design. Term of the design, this is very important. The term of the design is 10 years and can be extended to 5 years. That means the term of design patent is 15 years from the date of filing. After the 15 years, it is open for the public. That means public can copy that particular design without taking the permission of the author or owner. Geographical indicators. Geographical indicators cannot grant to the individuals, right? And it is always grant to a particular area. It is always grant to a particular area. Like if I give the example, Nagpur ke santre, Banaras ki sari, right? So Banaras ki sari is Banaras sari. The sari which is developed in Banaras is famous. Or the santra, orange of Nagpur, it is famous, right? Similarly, West Bengal के रसगुल्ले, ठीक है? इसी तरह से suppose I'll say you will find lot of geographical indicators. Even in Punjab, you will find the Fulkari work. Fulkari work of Punjab is very famous. Similarly, the chappals of Kolhapuri chappals, right? They are, but suppose I am developing the Kolhapuri chappal in Chandigarh and I am claiming that these are Kolhapuri chappals. No, it is not allowed. It is not permitted, right? Similarly, the Kanjivaram saris, these are very famous, right? And it is just giving to a particular area where the product is developed. The Agra ka petha, you will find petha everywhere, right? And they are claiming that these are the Agra ka petha, but the petha which is actually developed in Agra, they can claim these are the Agra ka petha, right? Suppose I am developing a particular commodity or device, I can file patent, I can file the design patent, I can file the copyright and trademark as well. Suppose I have a company, right? And my company name is suppose Premier, and my company is developing the pressure cookers. This is one of the example I am giving. So the pressure cooker, the working of the pressure cooker is different from other pressure cookers. Here I can claim the patent. I'll file the patent, right? And the size and shape of the pressure cooker is different. Color, size, shape is different. So I can file the design patent. Suppose I'll write the manual to operate that particular pressure cooker. How you will operate whenever you purchase a particular item from the market, you will find the manual, how you will operate it, what are the SOPs, what are the do's and don'ts. So those things are covered under the copyright. And a particular symbol which I will attach in a product. Suppose you will find the image of the Hawkins, how they are writing Hawkins, and they are putting the image on pressure cooker. Like here you will find the Premier. So this is a trademark. That means if I am developing a particular device and I have my own company, then I can file the patent, then I can file the design of same device, I can file the copyright of the same device, and I can file the trademark. Similarly, suppose you are going to purchase a particular mobile, you will see the example, the shape and size of the mobile, right? These are coming under the design patent, right? And the technology part of this particular mobile will come under the patenting part, right? And the information, brochures or the manual to operate that particular device is coming under copyright. And the confidential information, the confidential formula we are using that particular device, it is the trade secret. Similarly, in Coca-Cola, Fanta, they have their own trade secrets. They don't want to disclose the formula. But of course, they have disclosed the formula to the patent authority. But that formula, that disclosed formula is their own, they have disclosed for their own protection, right? That is called the trade secret. I think you might have understood the different tools of the IPR. Any question on this particular topic? Any question?
Sir, you can continue. We'll take the question answers at the end.
Okay. Now, whenever you are filing a particular intellectual property, you have to see the novelty of that particular work, whether it is novel or not. So how you will check the novel of your work? You have to do the prior art. And how you will do the prior art? Suppose in case of research, suppose I got an idea and I want to check whether that idea is already existing, whether that particular device or that particular thing is already developed. So how I will check that particular prior art, how I will do the prior art? I have to choose Google Patents. But lot of other tools are also there, which can provide the prior art facilities. Very, very in-depth prior art you can do. But generally people are using Google Patents because it is free of cost. So everyone is using Google Patents. But I will let you know the other tools also, but they are paid tools, and you can use those tools for prior art. And easily you can find the prior novelty of your device. So here you have to find out how you will do the how your device is novel, right? So you have to put on the Google Patents, and you have to give the detail of your device. So according to the keywords, you will find lot of devices which are already patented. Even you will find the US patent, you will find the Asian patents and Chinese patents, everything you will find over there. Now, from those patents, you can find the claims on the right side of the patent detail, you will find the claims. And you have to go through the claim, what that particular patent is claiming, and what is your idea and what is your claim. And you have to match the claim. According to claim, if your claim may match with the other claims, then you can rectify it, right? Or you can change that particular claim to some other claims, right? So similarly, you can see the claim of different patents and you can compare those claims with your claims, and you can prepare your document and you can claim the novelty and you can enhance the novelty. So that process, that finishing process is called the prior art search. So generally we are doing prior art with the Google search, Google patents. You can put on the Google patents and you can see on your computer. So prior art means everything that has been published, presented, otherwise disclosed to the public before the date of filing of complete specifications, right? Now, inventive steps. These are the, if you just claim that my system, my device is having some novelty, then you have to write down the inventive steps. What are the new steps you have done in your machine or in your device? That you have to disclose. Some of the things are non-patentable inventions. That means you can file the patents of those things, like under section 3A. I'll give some examples. An invention which is frivolous in nature, you cannot file the patent. Okay. Like the machine which gives the more than 100% performance, a machine that giving the output without any input, right? An invention's primary or intended to use or commercial exploitation of which could be contrary to public order or the morality, or which causes a serious prejudice to human animals and plant lives and environment, you cannot file the patents of those things, right? For example, here you can understand the things very well. Suppose I am developing a machine for gambling. I cannot file the patent of that particular machine. Right? Suppose you are developing a machine which will give the convenience to committing theft and the burglar. That is not allowed, right? Suppose you are developing a machine to break the lock, to break the house. That is not allowed. Suppose you are developing a machine for mass destruction, or you are developing a particular weapon for mass destruction. That is not allowed. That is not permissible. Next is, suppose you are developing a machine for the duplicacy of currency. It is not allowed. Right? Adulteration in food is not allowed. Cloning of human beings is not allowed. Suppose you are developing any method or machine or process for new society systems, that is not allowed. So you cannot file such kind of things which is used, which can be used against the human being. In non-patentable inventions under section 3I, any process for medical or surgical is not allowed. Curative or prophylactic is not allowed. Diagnostics, therapeutic, and other treatments of human being or similar kind of treatments are not allowed for animals, or free disease or free increase their economic value. It is not allowed. It is not at all permission. Process of administering the medicines orally. Suppose there is a different process to administer the medicines orally, it is not allowed. Or through the injection, it is not allowed. Right? Stitch-free incision or cataract removal, these are not permission. Method of cleaning the plaque from the teeth. If you are developing some new methods, that is not permission. Method of vaccination, that is not permission. art of curing the illness cannot be patentable. That you cannot file the patents, right? That is under section 3I of Indian Patent Act. Similarly, in section 3J, if you are doing any research on the plants and animals in whole or part of thereof that cannot or organisms, that is non-patentable. But including seeds, varieties and species and essentially biological process for production or propagation of the plants and animals, that is non-patentable. And there is a act, Farmers' Right Act, where we have to take the approval. Otherwise, we cannot file the patents. Now, in next chapter, I would like to just convey you how you will file the patent, practically how you will do it. Now, you just try to understand this particular table so that it would be much easy for you to understand the entire tools. In case of patent, you have to find out the novelty and inventive steps. You can just copy this particular table so that you can understand the entire lecture with the help of this table. If you are filing the patent, you have to find out the novelty. You have to find out the inventive steps and utility of that particular patent. And you will protect it from the manufacturers, right? And the term of the patent is 20 years, right? And registration is compulsory for that. And copyright, here you don't have to find out the novelty, right? Rather, it is just a literature work or artistic work or the software work, right? Sometimes people get confused. I have developed one software and I want to file the patent. That is not permissible. If you develop the software, you can do the copyright, right? And the term of the copyright, I have already told you, the life of the author plus 60 years. And the trademark, similarly, it is used for commercial use. Okay? And but you have to register for it. And confusing the resemblance and protection against confusing the resemblance, right? Similarly, trade secret, industrial design, and geographical indicators are there. And you will find the requirements and you will find the protection against the parameter and the registration system. How your intellectual property is different from the research paper. What is happening in case of research paper? Publication is post-analysis, but patent application, no evaluation before publication. And for research paper, you don't have to pay the fees sometimes. But some publishers are taking the fees, but generally in good journals, they are not taking the fees. But in patent application, yes, you have to file the fees. In research paper is variable, but in patent application, early publication is 1 to 1 month, 1 week to 1 month, and 18 months is the normal for the publication. If you want to do the early publication, you have to pay extra for that, right? And the research paper grant is the novelty, but in patent, novelty plus non-obviousness, both. And rights, in research paper, the right is on the author, but patent is the legal rights, right? We will not find any legal rights on research papers. Similarly, in commercialization, anyone can do commercializations of research paper, but in case of patent, only the assignee or the licensee can do the commercialization. Then types of rights, in case of research paper, it is global, but in case of patent, it depends upon the jurisdiction. That means if you are filing the patent in India, that it means it is valid in India. Similarly, expertise in significant part, it is practice and reserves. But in case of patents, it depends on the claims. I think I request everyone to please copy this particular screen so that you will be able to understand everything about IPR. So you can easily file the patents, you can protect your intellectual property. Now, the patent filing procedures. The patent rights are granted by the National Patent Office. And the protection for an invention must be sought in each country individually. Each country, they are performing their individual patent system, and they have their own patent authorities. But of course, we can file the international patents also by using the Patent Coordination Treaty that I will let you know in later stage. The Indian law of patents is enshrined in the Patents Act 1970. This is the Indian Patent Act, right? And it is operative in entire India, entire country. The objective of the patent law is provided over here. You can see the objectives. A statutory right to the owner. We are providing actually the patent. If you are filing the patent, it is giving a statutory right to the owner of the patent for certain period of times. After that, it will get open for the public, right? And within that period, you can sell the patent. You can get the royalty of that particular patent, right? That particular intellectual properties income. To disclose the invention and practice that invention and make it work, thus encourage the scientific research and new technology. To stimulate new inventions of commercial utility, to pass inventions to the public domain after the expiry of the fixed period. That means you don't have any monopoly of that particular patent, but of course, monopoly existing for a particular period. After that, the monopoly will release and everyone can use that particular patent without taking any permission. What are the benefits? Stop reinventing the wheels. Know that it is already patented, right? Patent and collaborations, money, fame, name, etc. These are the benefits. Grant of patent. To get a patent grant, the first most step is to file the patent. If you want to your patent should be granted, then you have to first you have to take the first step. That is, you have to file the patent. Then only you will be able to get the grant, right? And who can file the patent? Where to file the patent? How we will file the patent? These are the questions generally arises whenever a person is going to protect their intellectual property. So here I am giving the answer of each question. Who can file the patent? Any individual or jointly, one or more persons jointly can file the patents. By any person claiming to be true the first inventor. First inventor is the main person, right? By any person being the assignee of person claiming to be true and first inventors, right? But you have to submit the proof. By the legal representative of any deceased or person or assignee. If a person, suppose he or she don't want to put his name, he can give the name of his or her representative. But in case of research paper, it is not possible. Where to file the patent? You will file the patent with the patent office, appropriate office of the. You will find so many offices in India that I will let you know. But before filing the patent, your residence of applicant or domicile or the place of business you have to mention, right? If the applicant has no business, no domicile in India, the address for service in India is given in such applicant. That you have to give the proof that you belong to the country where you are filing the patent. These are the different patent office. One patent office you will find in Chennai, one in Mumbai, one in Delhi, then Kolkata. And the states, you can note down the states. You can copy this particular screen. The state of Andhra Pradesh, Karnataka, Kerala, Tamil Nadu, UT, Pondicherry, and Lakshadweep. These all are states are coming under Chennai office. Similarly, Maharashtra, Gujarat, Madhya Pradesh, Goa, Chhattisgarh, Daman Diu, and Dadra Nagar Haveli, these are come under Mumbai. Similarly, Haryana, Himachal, Jammu, Kashmir, Rajasthan, UP, Uttaranchal, Delhi, Chandigarh, these all states are coming under New Delhi. And rest of the India are falling under Kolkata office. You can check this particular site, ipindiaonline.gov.in, and you will find the detail how you will file the patent. You can do the e-filing also. But generally, we involve the patent attorney to file our patents, because patent attorney is taking the fees, and they just do the prior art by using the special softwares, and they have some expertness on those things, and they polish your application, they polish your idea. Suppose in case you are filing a case, you are using an advocate, the service of an advocate. Similarly, before filing the patent, we are using the services of patent attorney. But you can a particular individual can also file the patent directly with the patent office. So how you obtaining the patents? General procedures: filing of the application, publication of the application after 18 months, right? If you are giving the early publication fees, it will get published early. So pre-grant oppositions, representations by anyone, they can give the opposition at the time of publication, after the publication. After that, we have to request for the examination, that is generally called RFE. We request the patent authority for the examination of our patent, right? Then, after the examination, either they will grant the patent or they will refuse the patent. Once they grant the patent, they will publish the granted patents, right? And post-grant opposition of grant patent. Then this section will be initiated, the post-grant opposition of the granted patents. It is taken, that decision is taken by the controller. So this is the way to, this is the procedure to obtain a particular patent. Now, before 2005, once you will file a patent, it will get examined, then the application in order for grant, then the advertisement for the acceptance of the complete specification, then opposition of the interested person started. Then after that, it was decided that it would be sealing or granted. But in case after 2005, the system has been changed. Once you will file the application will get published either within 18 months or before 18 months. It depends upon the early publication fees. If you have been paid the early publication fees, it will get published earlier. Otherwise, it will publish after 18 months. Then this particular area is the pre-grant opposition. Now the examination will start, and you have to file the RFE, refer for the examination. After the examination, either they will application in order for grant, or it can also for the refuse. They can also refuse. After the grant, they will publish the grant. Then the post-grant oppositions will initiate. This is the procedure currently they are following. up to 2005. Now you can see the documents covering letter, and these are the Form 1, Form 2, Form 3, Form 26, and Form 5. You can just note down these forms, and you can check the contents of the forms from that particular site which I have already mentioned, and you will find the detail, the content of the form. Now specifications. Here you can give the provisional specification or complete specification, but no patent will be granted on the basis of provisional specifications. You have to give the complete specifications if you wish your patent should be granted, right? So what is the content of the specification? Title of the invention, field of the invention, background invention. You have to give the prior art searching, comparative or the review of literatures, right? Then object of the invention, summary. Then you have to give the brief description of the drawings. You have to give the drawings, and you have to mention the number, and you have to give the detail of those components number wise. Detailed description of the inventions, right? These are the provisional specifications, and these are the complete specifications. So you have to give the complete specification before filing the after filing the patent, so that it will get granted by the granting authority. And these are the fees. This is the latest fee structure. If a natural person, if a single person or a group of persons, the fees is 1,600 rupees. For a small organization, it is 4,000. For large organization, it is 8,000. Right. Similarly, the fees for each sheet of specification, in addition to 30, if it exceeds 30, right, then they are taking the fees 160, 320, 640 like this. And similarly, up to 10 claims it is fine, but more than 10 claims they are charging the fees. So this is all about the filing of patents, and you can go through the site website so that you will be able to understand the things. Otherwise, if you face any kind of problems, you can ask. Any questions, please? After the grant, we have to give the maintenance of the patents, like up to 6 years, it is 2,000 per year. But now the fees has been revised, so we have to check the latest fee. We are giving the maintenance of that particular patent, right? So this is all about the patents. Any question from anyone?
Thank you so much, sir, for your presentation. I request participants either put your questions in the chat box, or you can also unmute yourself.
You can unmute and ask.
You can unmute yourself and ask directly to
Yeah,
sir.
good afternoon.
Good afternoon.
This is Emmanuel George from Allahabad. I'm very thankful for giving the wonderful lecture, and we have just managed to take many things from you. So there is a one question from me. Like there is a one IP we cannot go for that weapon of mass destruction, right?
Yes.
So like in defense, when they go for a weapon for mass destruction, because they have to get patent, because only because that we are buying from different countries.
That is different. Those are the authorities. Even in biological, if suppose you are developing some biological things, you can develop, but you have to take the permission from the regulatory authority. The regulatory authority can give the permission, but in case of weapons, general persons, they cannot get the permission to develop and file the patents. Yes, in defense they can do. In DRDO they can do.
Like
but their involvement is there.
Like that of a local martial arts, right? Like a local martial arts, like Karate Pattu or something like that. They have their own defense, weapons.
Of course, sir. they have to take the permission from the authorized regulatory authority, right? And regulatory authorities' involvement is there to file the patent. Suppose I am developing a particular weapon which can do the mass destruction. I cannot file the patent of my own, right? If I am working with DRDO, if I am working on a DRDO project and DRDO's involvement is there, DRDO is a party is there, then the system is different, right?
Okay.
Sir, I have also a question. Sir,
Dr. Panda,
suppose, yes, Dr.
sorry,
Janardhan, you want to ask first? You please go ahead.
sorry to intervene, ma'am. You can go ahead. Yeah.
No problem. Please go ahead.
Dr. Panda, good afternoon. It was very fruitful and very beneficial presentation, and I'm very happy to understand more about IP.
Actually, within 1 hour, it is not possible to complete the entire
Absolutely.
IPR system. So I have skipped a lot of things there, but I have just explained some of the important points.
Yes. Sir, sir, I have one question. I think I'm sure you will be the right person to answer. See, from the Indian, perspective, the patent registration compared to global or developed economies or some of the developing economies, the patent filing rate is very low, very minimal.
Yeah.
And say I belong to Bangalore University, and from our side also we try to tie up with some of the innovators in the from the industry space. Even then, the encouragement from the different stakeholders is not that great. What do you think about it, and how to create a favorable ecosystem so that the
This is a good, very good question, Dr. Janardhan. I really appreciate. And we have also seen such kind of problems in our university, also in CHITKARA University. And in 2014, we have opened our Research and Innovation Center, and we have established one office of the patent facilitations, right? And the main thing is fees. Suppose a particular person or a student, they are innovating something and they want to file the patent. But what is the problem they are facing? They are not getting proper guidance how they will file the patent. Number two, they cannot finish their idea. It is very difficult for them to perform the prior art search. So we have developed one OPFLC system, Office of the Patent Facilitations, where the student will bring the innovation, and we experts are there. They will do the prior art and they will finish their innovation, right? And they will file the patent, and the university will bear the cost, right? And this is the only way to enhance the patent. But this is not possible in government universities. Yes, in private universities, we have taken the initiatives and we are paying the patent fees, and we have our own patent attorney. That means the student will just focus on the innovation. And after the innovation, the student will focus on the development of the prototype. And the student will not bother for the documentation purpose and documentation things. How I will write the document, how I will do the prior art search, and how I will put my claims. For that, the student will not get, not worry for that. And the student will be focused on the patent prototype development, right? So this is the only, we have to develop an ecosystem in universities and colleges which can provide the expert, prior art search expert, prototype develop expert, documentation experts, those who can help the students or the innovators to file the patents. Otherwise, everyone is innovating something, but they kill their innovations after that. They are not filing the patents.
Absolutely, sir. I agree with you, and thank you very much for this.
But the same thing is not available in. I feel really bad when I see the government universities, because they are not giving, they don't have the additional funds to do such kind of things. But yes, I can give one. I have given one idea to government university, and they are implementing under the CSR. Under the CSR, you can establish one innovation center, and you can take the help of CSR, and you can file the patents of innovators from the CSR money. That can be possible. Or you can develop a particular innovation center, and you can generate some funding, and through that funding, you can file the patents of the innovators free of cost. You can help them. So it may be one of the way to enhance the patents and the intellectual property in government universities.
Thank you, sir. Thank you very much. I think I will connect with you. I will take
Surely, sir.
yeah. So
Yeah.
and I thank the organizers and Dr. Anuradha.
Thank you so much, sir. I
for
request now
beautiful
Dr.
session.
Vasudevan. He wants to ask a question, I think.
Hello.
And one more thing, Dr. Janardhan. One more thing, Dr. Janardhan. Dr. Janardhan is there?
Yes, sir. Yes.
I would like to just convey you, after 2014, when we have established the OPPLC, our Office of the Patent Facilitations, every student, those who are after passing out, they have more than 4 or 5 patents in their head. This is the beauty of our ecosystem, in fact. And you can see the detail in the website also.
Sure, sir. Sure.
Yes,
Hello. Good afternoon. Hello.
Yes. Dr. Vasudevan, I'm listening. Please go ahead.
Sir, I'm having one small question. Is it mandatory for getting patented right for IPR?
Sorry, sir, I'm not getting your.
Is it mandatory for getting?
I'm unable to listen your voice, sir.
Hello.
Yes.
Hello.
Yeah.
Hello.
Yeah, I can listen now.
Is it mandatory for getting patented right for an IPR, and how to create awareness? These are all the 2 questions.
What is the first question, sir?
Is it mandatory for getting patented right for an IPR?
Right, sir, I'm not getting your question.
Suppose
It is mandatory.
if anybody is having some innovation, whether is it mandatory for him to get patented right?
I'm unable to understand your question, sir. Can you write your question on chat box?
Sir, kindly write your question in chat box.
Hello, sir. Now it is audible, sir. Is it audible now?
Yeah. Now it is audible. Yes.
Sir, is it mandatory for anybody who is responsible for innovation to get patented right? Number 1. And number 2nd question is how to create awareness. These are my 2 questions.
Okay. If you are developing a particular innovation,
yes,
then you have to file the patent, or you have to protect it with the Copyright Act. There is no through the IPR.
Okay.
There is no alternate way. Otherwise, you cannot claim this is my innovation.
Yes.
That innovation may get still by anyone.
Yes.
So immediately you have to file the patent.
Yes.
And immediately you have to give the provisional disclosures, right? After filing the patent, after getting the patent number, you can give the detailed disclosures, no problem, right? So this is the only way to protect your innovation.
That means you are getting legal protection.
Yes. This is the legal protection you will get. Okay. And your next question, what is your next question, sir?
Creating
how you
awareness.
Generate the awareness. And this is the only, awareness, we have to, what we are doing in our university, we have kept the innovation box in most of the places in our university. And whenever the student will get an idea, he will write the idea on a paper and give his detail and drop the paper in innovation box. Okay. And every week we open the innovation box and we start reading the ideas. and we call that particular student. See, generally when the student is generating the idea is in 2 lines, right? But that particular idea, we need to finish it. We need to do the prior art. Who will do the prior art? The student cannot do the prior art. The expert can do the prior art, right? Then after doing the prior art, we discuss with the student and file the patent, right? So these things we have to give the awareness to the students, to the staff, so that they can innovate something, and we have to develop one ecosystem. So automatically they will start thinking the things in innovative way, because they know we can protect our innovations very easily, right? If we enter into the office of the patent facilitations, we can protect our innovation, right? So they will not worry for the fees, they will not worry for the documentation. Suppose I am going to file a case. Suppose someone steal my watch, right? This is my problem. I'll go to police station. I'll file the case. Then after that, I will shift my case to advocate. My advocate will do the everything, documentation and everything. Similarly, if I am filing the case and I will do the documentation and I will fight my case in court, it is a burden for me, right? Are you getting Dr. Vasudevan?
Yes, sir. Yes, sir.
Thank you so much, sir. Thank you so much, sir. I also have a question, and after this question, we'll go for vote of thanks, as we have, due to time constraint, we have another meeting too. And I request all the participants, you can send your questions to us. We'll directly mail to Panda sir, and he'll reply all the questions.
Yes. I'll just share my
yes,
mail ID.
you can
share
your email ID in the chat box.
Also.
Right, sir.
You can ask the questions. We can do the debate also. No problem for that. Because everyone is not having the complete knowledge.
During the vote of thanks, we'll also send feedback link also. Kindly fill the feedback form correctly, as on its base we'll issue the certificates. Sir, I have a question. Suppose we only design something, means we don't create the product, we have a design only. Suppose anything design can be of anything. Can we also find the patent for the same?
Yes. You can file the design patent.
Right,
and
moreover, but that design may fail.
The design patent can get approved within 6 months to 1 year.
Okay, right, sir.
But
and
there you have to give the detail of the design, right? Picture of the design, the components, and how it is different from others, that you have to justify, right?
So design may fail later because due to maybe because we have not created the product as yet. We just have a design in our mind, but it may not be the same.
देखो डिजाइन में आप में भी आपकी इनोवेशन होती है, ठीक है? आपको एक मैं डिजाइन का एक एग्जांपल देता हूँ. एक हमने एक सैंडल डिजाइन किए, ठीक है? सैंडल कहाँ से डिजाइन किए? हम कहीं पे खड़े थे एक ऑडिटोरियम के बाहर और चीफ गेस्ट की वेट कर रहे थे. तो चीफ गेस्ट वहां से मतलब अपने ऑफिस से ऑडिटोरियम तक जब वो आ रहे थे तो उनके पीछे कुछ और भी बंदे थे जो मेरे नोन थे. उसमें से एक लेडी थी, वो लेडी भाग के आ रही थी और बड़ी मुश्किल से वो पहुंची वहां पे. तो पहुंचने के बाद हमारे को बोली कि मेरी सबसे बड़ी प्रॉब्लम थी हाई हील चप्पल. मैं हाई हील चप्पल में मैं भाग भी नहीं पा रही थी और उस चप्पल को मैं उतार भी नहीं पा रही थी. तो वहां पर एक आइडिया आया, क्यों ना अगर ऐसी प्रॉब्लम्स आती हैं तो बाय यूजिंग स्मार्टफोन उसके हील को कम कर दें, और जब वो पहुंच जाएगी तो उसके हील को अपने आप बढ़ा देगी वो. तो हमने एक सिस्टम डेवलप किया एक चप्पल का, जिसके अंदर एक एक्चुएटर और एक हीलिंग सिस्टम. तो उसमें क्या है कि अगर एक लेडी को जल्दी कहीं पहुंचना है ना, तो वो फटाफट स्मार्टफोन ऑन करेगी, ब्लूटूथ के थ्रू से वो अपने जैसे साउंड को कम करते हैं ना, वैसे प्रेस करेगी, हील उसका छोटा हो जाएगा, ठीक है? फिर वो फटाफट भाग के चले जाएगी जहां पहुंचना है, और पहुंचने के बाद अपने हील को ऊपर करते हैं, ठीक है? नो डाउट इट इज ए लग्जरी आइटम, लेकिन इसका यूटिलिटी पेटेंट भी हुआ, डिजाइन पेटेंट भी हुआ, और कई चप्पल कंपनी जो है इस पेटेंट को खरीद के भी ले गए.
राइट सर।
उसमें रॉयल्टी हुई, हमारी इनकम भी हुई, और बहुत ही सस्ता सिस्टम। और वो हील को हम दूसरे चप्पल में भी शिफ्ट कर सकते हैं। साथ में आपके फोन में एक ऐप है, वो ऐप से ही आप उसको कंट्रोल कर रहे हो।
राइट।
जब एक हाई हील पहन के एक लेडी जा रही है तो उसके हाथ में एक मोबाइल फोन भी होगा, ठीक है, तो वो हील को जो है अपने मर्जी से वो एडजस्ट कर सकते हैं। कभी इमरजेंसी आ जाती है ना, शी कैन एडजस्ट।
Thank you so much, sir. Now I request my
Anuradha, before you give the vote of thanks, I hope Panda ji is not able to look, but the 100 to 200 participants are still with him. Very, very correct.
Thank you, ma'am.
How efficiently the
Credit goes
lecture
to
has
you,
been
ma'am.
delivered.
This is due to your name and pen.
And I feel rather the Zoom meeting should have not been conducted, because many of the persons are in the waiting room and we are not able to admit. So let's hold the next meeting with S.N.PANDA with on WebEx, because we have a capacity of 1,000 persons or attendee can attend it, you know.
Next time, madam, you give me 2 hours at least, so that I'll explain the things with examples.
Yes, sir.
I have lot of examples, and I have my own 55 patents till now.
Very good. Let's clap for you.
Already granted. Right.
Wonderful.
Sorry, sir, I was having.
If I want to explain my patents, then it will take around 3 to 4 hours. So at least the student can, the person can understand the things by using the examples, so that they can file the patent. They will get enthusiasm for that.
बिल्कुल ठीक कहा पांडा साहब आपने। हमने अगली बार वेबएक्स पे कर रहे हैं, क्योंकि हम कई लोगों को एडमिट नहीं कर पाए, क्योंकि हम किसको कहते हैं कि आप बाहर जाएं और किसको कहते हैं कि आप अंदर आएं। So I will surely we will be holding the next meeting on WebEx, and we will go for 2 hours, sir. And it was a wonderful lecture. I really appreciate you for delivering such an intellectual, very innovative, very thoughtful, और एक thought provoking lecture था. But the formal vote of thanks will be given by our I hope Nishu Bansal, probably Anuradha ji. But मुझे ये था कि मैं सर को ये बता दूं कि अभी भी इतने जो participants हैं, they are holding your talk, so that shows the credibility of the speaker.
Ma'am, सब आपके आशीर्वाद से ही हो रहा है जी।
Ma'am, we were having 400 registrations.
Yes.
Maybe because Dr. Panda was a resource person.
हाँ, तो बात ये है कि आपको ये वेबएक्स पे करना है अगली बारी, not on Zoom.
Sure, ma'am. Sure.
Yeah. So we can call Nishu now.
Okay. Now I request Nishu ma'am for formal vote of thanks, and I request Anchal kindly post feedback link as well.
Are you sending the feedback link to?
Thank you, ma'am. Thank you, Dr. Anuradha. It's my. Am I audible?
Madam, are you sending feedback link to WhatsApp?
It will be in the chat. It will be in the chat box, sir.
No, sir. It will be in chat box. We have already sent. You can fill.
Okay.
Yeah.
Thanks, Principal ma'am and Dr. Anuradha. Am I audible?
Yes, ma'am. You are audible.
It's my proud privilege. It's my proud privilege to thank Dr. S.N.PANDA, Director Research, CHITKARA University. सर का लेक्चर जो है आईपीआर और कॉपीराइट और पेटेंट पे इतना थॉट प्रोवोकिंग था, जैसे मैम ने बताया है कि हमें इतनी ज्यादा नॉलेज मिली उसके बारे में। सर ने हमें इतना एग्जांपल जो दी वो इतनी डाउन टू अर्थ थी, जो हम सोच भी नहीं सकते कि इसका भी पेटेंट हो सकता है। और वो सर ने ऐसे बताया कि हम सोच रहे हैं कि हम अपने कॉलेज में कैसे पेटेंट जो है वो बनाएंगे। एंड माय सिंसियर थैंक्स टू डॉक्टर किरण आंगरा, जिनकी गाइडेंस के अंदर जो है हम ये सेमिनार जो है, ये वेबिनार ऑर्गेनाइज करते रहते हैं। मेरी इकाब टीम, जिसके साथ जो है एक टीम वर्क के साथ हम वेबिनार ऑर्गेनाइज करते हैं।
निशु मैडम, कैन आई प्लीज होल्ड फॉर 1 मिनट? किरण मैम।
यस सर, श्योर सर।
यस सर, यस सर।
आपके कॉलेज के कोई भी बच्चा, कोई भी स्टाफ अगर कोई भी इनोवेशन करता है,
करेक्ट,
तो वो इनोवेशन को पॉलिश करना, फाइल करना, उसकी फीस पे करना, ये सारा हमारा काम होगा और उस बच्चे के नाम पे फाइल होगा।
अरे वाह, दैट इज वेरी गुड।
आप अपना इनोवेशन सेल बना लो, इनोवेशन सेंटर बना लो, ठीक है, आप पेटेंट सेंटर बना लो, ठीक है। और
सर हमने
उसकी
इनोवेशन सेंटर बना दिया
जिम्मेदारी
है।
हम लेते हैं। आपसे 5 पैसे भी खर्च नहीं होगा बच्चे का, सारा
Okay.
चिटकारा यूनिवर्सिटी पे करेगा और पेटेंट फाइल होगा।
डन सर, वेरी गुड, दिस इज फ्रूटफुल। मुझे
ये
लगता है मेरे साथ और भी
मैं
पार्टिसिपेंट्स हैं।
ये अपॉर्चुनिटी इसलिए दे रहा हूँ क्योंकि मैम बचपन से आप लोगों को हम देख रहे हैं, तो ये मेरे लिए
यस सर, आपको आज
आप
आपकी
जरूर
ग्रोथ,
करवाओ।
यस सर, वी रियली अप्रिशिएट योर ग्रोथ। You have really grew to these heights. I have seen you from the very beginning, and now I am seeing you in Chitkara. So your journey is interesting, your journey is inspiring, and I hope sometimes when we will give you 2 hours, we can explain how you rose to this level. So I really appreciate you, Dr. S.N.PANDA, and I hope you will surely rise to heights. And of course, we, your associates, will always be there, and I hope you will be always fruitful for us. I know that. Yes, sir. So Nishu can continue, please.
सर आपका ये जो है, आपका ये मैसेज ही हमारे लिए बहुत मोटिवेटिंग है। जब आपने सर हाई हील का एग्जांपल दिया तो लगा कि हम भी कुछ इनोवेट कर सकते हैं, हम भी उस पे कुछ काम कर सकते हैं, मतलब इस पे भी पेटेंट किया जा सकता है।
बस मैम आप इनोवेशन सेंटर संभाल लो, किरण मैम से परमिशन लेकर के, बाकी काम मैं कर लूंगा आपको, डोंट वरी।
सर मैम तो हमें बिल्कुल टाइम टू टाइम गाइड करते रहते हैं, मोटिवेट करते रहते हैं, तो डेफिनेटली हम सर नेक्स्ट ईयर में जरूर कम से कम ये श्योर करते हैं कि 1 या 2 तो पेटेंट हम करवाएंगे ही करवाएंगे आपकी गाइडेंस के अंदर।
मेरे लिए तो अम्बाला इम्पोर्टेंट है, मेरे लिए मेरा बर्थ प्लेस उड़ीसा इम्पोर्टेंट है, तो यहाँ के जितने भी कॉलेजेस हैं मैं सबके लिए मैं काम कर सकता हूँ, फ्री ऑफ कॉस्ट फाइल करेंगे। ठीक है मैम।
Thank you, sir. And my sincere thanks to the participants जो कि बेंगलोर से, अहमदाबाद से, each every corner of India से जिन्होंने ज्वाइन किया, सर को सुना, और हम सर से अभी कमिटमेंट ले रहे हैं कि नेक्स्ट वेबिनार जो है हम शॉर्टली करने जा रहे हैं, और जैसा कि मैम ने कहा कि हम वेबएक्स पे करेंगे और सर के कम से कम सारे पेटेंट सुनेंगे ताकि हम मोटिवेट होके कुछ और पेटेंट अपने नाम भी सर की गाइडेंस के अंदर करवा सकें। So thank you sir, thank you participants,
thank you,
thanks a lot, thank you very much.
Thank you ma'am.
Thank you, doctor.
Participants, we are waiting for you to fill the feedback form so that we can end. Kindly fill it within 5 to 10 minutes. We are here for 5 to 10 minutes more. Those who have failed, kindly leave the meeting. Kindly fill the feedback form. We are waiting for you. Those who have failed, kindly leave the meeting.